We are back here on Radio Law Talk. And where are we?
We're going to talk about the bartender.
Yes.
So we have our wonderful affiliate, KBDT in Dallas, Texas. They are what is it, Cal? Big Talk?
Dallas Talk, BDT, Big Dallas Talk. 35,000 watts of AM flames being thrown out into the air over the Dallas Metroplex.
That is a big, big station that carries us. Thank you for carrying us. But this is what's going on in Texas. And Todd and I were talking about this during the break. You know, we in no way, just so you know, are ever in any way trying to downplay what happened in this tragic incident where this crazy guy goes and kills eight victims?
Eight people at a football watch party in 2017, I believe, in Plano, Texas.
Yeah, he goes crazy. So before that, let's set up what happens. Okay, first of all, in Texas, there's a law, and I tweeted it out to be, generally speaking, is a bartender's got to be very careful, or anyone serving alcohol, if they serve it to someone that's basically known to be drunk or is basically, well, I could read it, but they have knowledge that the person is impaired.
They call it a habitual drunkard or an intoxicated or insane person. And for those of you that are nerds that like to really look up the law, that is the Texas Alcohol Beverage Code, Section 101.63, sale to certain persons.
Yes, and
isn't there a legal definition for drunk?
Well, hold on.
I mean, there must be.
Yeah, Cal. So it says, quote, at the time of the provision, I'm quoting Section 2.02, at the time of the provision occurred, it was, quote, apparent to the provider that the individual being sued served or provided with alcohol beverages was, quote, still quoting, obviously intoxicated, and I underline obviously, to the extent that he presented a clear danger, I'm underlining, by the way, a clear danger to himself or others. So that's the general rule that these bartenders / alcohol, people who are serving alcohol in Texas have to abide by. Now, let's set that up. Don't forget, this gal that was arrested for this incident who served this wacko some alcohol probably is making minimum wage, working for tips. You know, and Todd, you brought out a very important point as a former prosecutor in Tennessee and California, and now as a defense lawyer. How cross-examine our police officers when they say someone's drunk? They have to be just nails on doing everything proper.
Absolutely. I mean, look, so I prosecuted DUIs and I have defended DUIs, and the issue here
DWIs in some states.
In some states, driving while intoxicated due to alcohol. The issue here is, what are the officers' qualifications to determine whether somebody is intoxicated? You know, they do their field sobriety test training in the academy. They have to maintain that certification. They've got to be certified on the devices that they use, the breathalyzer, the preliminary alcohol screen device. I mean, there's a whole host. And if you're a defense attorney, you're attacking the qualifications of a person who does this for a living, determines the intoxicated nature of individuals, and is specially trained to do that. Okay, how are we supposed to say that a bartender working for tips, I mean, if an officer can have their qualifications challenged based upon everything, how are we supposed to say that the bartender, and I guarantee you they don't have, if they have any training at all in observing or identifying intoxicated to the point that you're so impaired that you can't make rational decisions, how is this person going to be trained or prove they have any training comparable to a police officer?
Now here's the argument. Now on their side, on the prosecutor's side, this is from this individual that they've arrested. It's a young gal, Lindsay Glass. She's 27 years old, and it's called Local Public House in Pleld. And she tweeted out after this individual, and his name's Spencer apparently, after he came in, she said, quote, Spencer has a big knife on the bar and is spinning it and just asked for his tab and said, I have to go do some dirty work. She had ... She calls him psycho. Okay. The first thing is, everyone's like, well, this is a pretty clear case. Well, some people can argue. Look,
yes.
He was so drunk, he was stumbling outside. She still served him alcohol. My argument is not specifically on this case.
When you're done, I'm going to put my hat on as the defense attorney, how I would attack that.
Okay, good.
Okay?
I want you. But what I'm trying to say is, where does that slippery slope end? What I'm trying to say is, where's the line? If he wasn't tripping and out in the patio area, if he didn't have the night and spun that and still went and did what he did, is she liable? Where does it end or where does it stop?
And if she says he was psycho, she didn't say he was drunk.
Yeah.
Now, that to me is a pretty interesting thing. She didn't say the guy was so drunk that he was, and he's psycho. She said he was psycho.
Now, there were texts that she sent earlier in the day that referenced that she was aware of his drinking pattern. I believe those texts said he had 2 gins and he only had 2 beers and a shot when he came back. I think he was at another bar. So that was reference to earlier in the day he had 2 gins and he only had 2 beers and a shot when he came back. So he had 2 gins, left, then came back and had some additional stuff.
And that's the issue right there. Again, call us at 855-LAW-RADIO if you want to talk about this. But that's the issue I bring up. So now here she is trying to analyze the situation. She's probably got a bunch of customers around that she's trying to serve. I don't go to bars, but I do go to restaurants, and I sit at the bar. Those bartenders are flying.
Yep.
They don't have time to sit there. Can they quickly look and try to analyze? Generally, yes. Anybody can. But the fact is they got this order and then that person, and they're running with their heads cut off. And here she's trying to figure out and analyze this situation that puts a lot of onus on a bartender at 27, making minimum wage and working hard for tips.
Okay.
$7.25 in Texas, by the way.
Okay. So let me put on my defense attorney hat. The first thing that a defense attorney does is they look philosophically, I never like to refer to things as bad facts for me. That puts me in a bad frame of mind. We have good facts, and then we have facts beyond change, things I can't do anything about. I'd never refer to something as bad facts because it puts me in the wrong frame of mind in terms of defending a case. So one of the facts beyond change that we have here is the fact that first she seemed to know the guy because she referred to him as Spencer, okay, and she was aware enough about him to know what his drinking pattern was earlier in the day, because that might have gotten that from the bar tip or the bill that she gave him. But here are the things that I'm going to do as a defense attorney.
By the way, but we say this, you don't practice in Texas.
I don't practice in Texas.
So we don't know all the details.
That's
we're just
right.
talking in general. Just so you know, we're talking in general.
So the first thing that I do is I'm going to try to attack the big, what appears to be the smoking gun, this reference to the knife on the bar and all of that. If that knife was not out while he was drinking and she only observed the knife, as the text seems to indicate, at the time that he asked for his bill, I'm going to seek a motion that none of that evidence should come in as irrelevant, because that has nothing to do with my observations of intoxication. And even if I had observed that he was intoxicated, the fact that I didn't see the knife or she didn't see the knife until the bill came, why would I have known to stop giving him alcohol? I didn't see the knife until the bill came.
That was at the end.
That was at the end. And because it was the end, it's the prejudicial impact substantially outweighs any probative value, anything it might have to do to whether or not I'm culpable. So I'm going to seek to try to get that out. May win, may not. But the other thing that I'm going to look at here is this drinking pattern. He had 2 gins, those 2 drinks, and he had 2 beers and a shot when he came back. So we got 5 drinks total. 2 gins, 2 beers, and a shot. Now, on average, if they're doing normal drinks, each drink will raise his blood alcohol level about a 0.02. All right. Now, if we are talking about a drinking pattern, because he was here earlier in the day, left, came back, and we don't know if she surmises that he might have gotten alcohol somewhere else, but doesn't know. We're talking if this was over a 4 or 5 hour period and he's burning alcohol, metabolizing it at about 0.02 per hour, 5 drinks over 5 hours, your blood alcohol level is not going to get above a 0.01.
And does it matter, Todd? You know this more than I do. His size. What if he's a big dude?
He metabolizes it quicker than somebody who's 115 pounds, 5'2". So the question here is, does this drinking pattern even mean that a person would be so intoxicated they couldn't drive? And the last thing coming up on the break is, If I was to tell you that somebody leaves the bar drunk, what kind of harm, 9 times out of 10, would you think they would commit? Probably a driving offense or somebody got hurt, not going to a party and killing people with a machete.
Yeah, and the guy's crazy. So,
yes.
I mean, now she has to figure out craziness. Like I say, radio law talk, the facts sometimes are true, but he actually was using a gun, and you mentioned machete.
Well, and arguably that, from a defense standpoint, that cuts in her favor.
Right.
No pun intended. And it's in her favor because she, in her text, it says he asked for the check while having a big knife on the bar, spinning it. Well, the knife wasn't even the instrumentality used to commit the murders.
Right.
So that would be further evidence as to why that statement should be suppressed, because it's got nothing or not used, because it's not relevant to whether or not she knew he was intoxicated. All right. I want to read this really quickly here. So the code that Fred read says a person commits an offense if the person with criminal negligence sells an alcoholic beverage to a habitual drunkard, intoxicated, or a sane person. Criminal negligence is defined as a person who acts recklessly or is reckless with respect to circumstances surrounding the conduct or the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist that the result will occur. All right. I mean, it's a long way of saying that you're criminally negligent if you do this, and it's highly likely that the result that happened was going to occur. And that's why when we went to the break, I asked the question about if you were to ask about the risk that occurs, people would most likely say, you let a guy leave, he had a 0.33 blood alcohol level, most likely it's going to be a vehicle accident where somebody dies. It's not a shooting.
Is there a legal standard for highly likely?
Well, see, that's why. Is
that a dumb question? This is probably a silly question for me to ask, but I'm thinking in court, wouldn't you say, well, Your Honor, what does highly likely mean?
The answer is probably yes. There's probably some case law on it, but I don't know what it is, and it's going to be whatever it is in Texas,
sure,
what that is.
Sure.
But yeah, but I put the three most important words are apparent, obviously, and clear danger.
Absolutely.
Those are the three. But to me, to reach that level, to me, it's got to be really high. You've really got to know what's so dead obvious.
Well, and here's an anecdotal thing from my career as a prosecutor. I had a case once where I was prosecuting somebody for a DUI, and we had the surveillance video of when they were booked into the police station, okay? And so I'm watching the video. It shows the person. They come in. The intake officer is asking them questions and stuff. We don't have the audio, but clearly it's give me name, age, height, all that kind of stuff. They take the stuff out of their pockets, and then they took this person over and they put them on this machine, a platform, and the platform physically moves about 3 feet to the left and 3 feet to the right. It's a scanner to make sure that they're not trying to conceal anything in a body cavity or anything like that, right? And it comes back, and this thing moved left to right. The person didn't grab the rail, sat there, and I'm watching this as a DA going, well, that person certainly doesn't look intoxicated. They then left, went and sat down. Phlebotomist comes in, takes the blood out of the arm. We tested the blood that was taken right after the thing moved. 0.41.
That is hammered.
Blood alcohol level. 0.41. Now, comatose is 0.5. 0.4 to 5. Death is just a little bit of 5. 0.41. My point is, you know why DUI is 0.08 or higher? Because before they gave an actual limit, you'd have people coming in as a defense saying, you know what, I can handle my alcohol, I can handle my liquor, and they didn't want these prosecutions to end up being, well, I got to prove that you're a lightweight drunk or you're a heavyweight drunk and that you're only drunk if you're a 0.2. They finally said, you know what, forget all that. We're just going to say if you're 0.08 or higher, you're legally drunk for purposes of driving. Because if you don't have that, you don't know how people react. And if this guy's a habitual drunk, as the code says, then they can operate and appear to function normally with a higher than normal blood alcohol level.
We have an affiliate in Utah. I want to mention in Utah it's 0.5, and that may end up being a revised national standard. And basically, Todd, I think what they're really trying to say is we have a zero tolerance, but we know people are going to have a little bit of something to drink. But look, don't drink and drive, and they're keeping lower and try to turn it into a zero-tolerance environment. That's what it appears to me.
You're right.
Well, what's interesting, so let's talk about this Lindsay Glass. This law in Texas, the fine is up to $500 and up to a year in jail or both. So it's not a huge, penalty, but again, she's not going to want that on her record. Here's the other thing that's interesting. The other thing that's interesting is a lot of this is coming up because what happened is, and again, I'm a plaintiff's lawyer and I'm all for this, but the victims' families have filed lawsuit against the bar for negligently overserving Haight. And now the issue's going to be this is my question. How do you connect the dots? I'm saying that without in legal terms. How do you connect the dots? How is it foreseeable that this bar and its employee would have foreseen that he would have gone out and shot these people and killed 8 individuals maliciously from serving them too much alcohol? Is that foreseeable? That's the question.
I think it goes back to I think that if somebody leaves the bar, it's foreseeable that they can get into an accident and kill somebody in the car. Right? I think that is typically the scenario. Somebody leaves the bar, they get behind the wheel of a car, especially if you see them leaving the bar and they're drunk and they got the keys or they left the keys, whatever. That is far more likely than somebody going and shooting up a house.
Now, next question that I have, and of course, insurance is a question here. A lot of places have errors and omissions insurance. They have general liability. Can you insure a bar against over-serving?
So it depends. That's what I'm going to ask. So there are a lot of, again, I don't know all the states. You seek local counsel in Texas to answer this question. But in general, there are some states and some that follow a general rule that says, we're not, as an insurance company, going to cover you for any quote, criminal acts of your employees or of you individually. So if they deem that she committed a, quote, criminal act, they can argue you're not covered for your insurance because she served alcohol in, quote, illegally according to this code section. So, but I don't know. Every policy is different. They'd have to check their policy, but you better double check your policy and see that.
What's baffling to me on a criminal standpoint with this is that misdemeanors in both jurisdictions that I had practiced in Tennessee and California, and I thought this was pretty much uniform, the statute of limitations on a misdemeanor is typically 1 year. 1 year from the date of the offense, that's how long the people have to file this. Now, this incident happened back in 2017. She was just arrested a couple of weeks ago. So I don't know how Texas is getting around the 1 year statute of limitations, if indeed that applies to a misdemeanor, to file a case and place an arrest on somebody for an incident that happened almost 2 years ago. It happened in September of 17, so we're talking somewhere along the lines of 19, 20 months?
Yeah.
So I don't know how they get around that statute of limitations.
Maybe they have a 2 year statute. We don't know. But this is all interesting stuff about this. We're going to follow this case closely, but I just think it's just very interesting how this puts an onus on these young, most of them are young women and men who are serving and just trying to make a living. What a tragic situation, and not in any way downplaying the death of these wonderful people.
But to pin it on the bartender secondarily, to me, just smacks of a little overreach. That's just my own opinion. I'm no lawyer, and you know that. I'm just thinking from a person sitting on the outside.
Right.
Doesn't that seem like overreach?
Well, I think one other consideration we have here is, as I looked at this law, the problem I had was that I understand what they're trying to do. I think that the law has a lot of problems in terms of how you actually enforce it and what you can actually prove. And what I see with this case here, I don't know how many they've prosecuted, but if this one doesn't turn out well for the prosecution, this could very well be the way for the prosecutors to say, see, this kind of a law doesn't work. Let's go back in and fix it so we can actually have something that's enforceable, that protects the harm we're trying to protect against, because this one isn't doing it. But you got to have one case to run through to see how it works, and this one certainly garnered a lot of attention.
Yeah, and I think this one, no doubt, if she is convicted, it'll go to the Supreme Court, I would think. And probably she might plead, to be honest with you, and the prosecution might not want to run this through the courts due to the fact they want to make sure that this is going to going to continue to be a law. Also, civilly, it might go to court, too.
Yep.
So we're going to be back with hour number 3. Thanks for joining us. It's just Todd and I and Cal, the 3 Musketeers. We'll be right back.